There are now new clauses in the Renters' Rights Bill that will affect every landlord, and they concern the way we will handle rent paid in advance once a Renters' Rights Bill comes into force. These rules are a big deal, and all landlords and letting agents need to understand them. But they're complicated. And I'm a solicitor, and it's taken me a couple of days to get my head around the rules. Now, who am I? I'm Suzanne Smith, and I worked as a solicitor in business for 25 years before I became a landlord in 2019. And I run the Independent Landlord blog and this YouTube channel to put my legal experience to good use by explaining lots of things to do with being a landlord, including the Renters' Rights Bill. Disclaimer: this isn't legal advice. Please don't take anything you see on YouTube as gospel, even my videos. And I do my best to keep out of all the politics.
But the bill will also ensure that good landlords enjoy simpler regulation,
even when it's hard. Let's start with the easier part of the rules, the rent periods. So it's a fundamental part of the Renters' Rights Bill that a rent period can't be longer than 1 calendar month. And if a tenancy already has a period that's longer than a month when it comes into force, then it will automatically become a maximum of 1 calendar month. This means that landlords won't be able to have clauses in their tenancy agreements that state that a rental period is, say, for instance, on a quarterly or a termly basis, for instance, for students. And if there's a clause like that in a tenancy agreement, it will become null and void once the Renters' Rights Act comes into force. This includes existing agreements, and these clauses won't have any effect once the new tenancy system comes into force sometime this year, and maybe as early as July, although I'm hoping, perhaps naively, that it will be later in the year. Let's move on to the payment of lump sums in advance. Here's how Matthew Pennycook explained it in the House of Commons.
New Clause 14 would limit the amount of rent that a landlord can require to a maximum of 1 month. It would prevent unscrupulous landlords from using rent in advance to either set tenants against each other in de facto bidding wars or exclude altogether certain types of renters who are otherwise perfectly able to afford the monthly rent on a property. It does so by amending Schedule 1 to the Tenant Fees Act 2019 so that any payment of rent made before a tenancy agreement is signed will be a prohibited payment.
This means that the sorts of upfront lump sum payments, such as 6 months, which landlords sometimes ask tenants to pay if they don't have a good credit history or they're new to the country, will be banned. This didn't really come as a surprise. It's what we thought they would amend the bill to say. However, it goes a lot further than that. Landlords are going to have to be very careful about when they ask for the initial rent, in other words, the first month's rent to be paid, and when they accept these pre-tenancy rent payments. Let's now turn to the new amendments that ban pre-tenancy rent payments. A new category is being created under the Tenant Fees Act called a prohibited pre-tenancy payment of rent. And if a landlord or a letting agent accepts a pre-tenancy rent payment, they will breach the Tenant Fees Act and can receive a penalty from the local authority. Okay, what's a prohibited pre-tenancy rent payment? It's a payment of rent in advance before the lease is entered into. And when they say lease here, they mean a tenancy agreement for an assured tenancy. So not a long-term lease over 21 years. What does before the lease is entered into? I must admit, I did scratch my head about this. It means that after both parties have signed the tenancy agreement, and I think there's been some sort of consideration, which means payment, made by the tenant. And that's what you need to have for a valid contract under English law. The consideration can be the payment of the tenancy deposit. So what about the initial rent payment? The clause defines the initial rent as the rent that is payable for the first rent period or any later rent period, which ends during the initial 28-day period. And here, the initial 28-day period means the period of 21 days, beginning with the first day of the rent period. A bit of a mouthful. Landlords can ask for the first rent payment, which can be equal to but no more than the rent for a calendar month, once the tenancy agreement is signed. In other words, it's been entered into. And what I think this means, but please note my disclaimer, this is just my best guess, and it's all very fluid and it may change. But what I think this means is that you can ask a tenant to pay a holding deposit of up to 1 week's rent as usual, and that can be set off the first rent payment if they pass referencing and you go ahead with the tenancy. And if you want to go ahead, you can ask the tenant to sign the tenancy agreement and pay the tenancy deposit of up to 5 weeks' rent. And then the landlord or letting agent signs the tenancy agreement, and it's considered that the lease has been entered into. But what you won't be able to do, as the rules now stand, and I hope they change them, is ask the tenant to pay the first month's rent before the landlord signs, as this will be a prohibited pre-tenancy rent payment. You got that? Because it's taken me a while to get my head around it.
The bill will also ensure that good landlords enjoy simpler regulation.
You can ask the tenant to pay the first month's rent before they move in and accept it, but it won't technically be due until the first day of the tenancy. And the landlord will be bound by the agreement and will have to let them move in, even if they haven't paid that first month's rent. And if they haven't paid it, it's just the same as any other form of rent arrears. So this means that when a tenant is moving into a new property, there will be 3 payments. 1, the holding deposit. 2, the tenancy deposit. And 3, after all the parties have signed, the tenant can then pay the first month's rent.
What?
I've written to my MP about this because I think it's ridiculously complicated. And I hope they simplify this so that the landlord and letting agent can just do it the way it is now, that first month's rent can be paid at the same time as the tenancy deposit. But, I don't normally talk about politics, so I'll move on. Also, I should point out that just like the wording about rental bidding, it will be a breach of the Tenant Fees Act if landlords accept pre-tenancy rent, even if they didn't ask for it. So say you have a tenant that you like, they pay a holding deposit, and then they sign the agreement, they pay the tenancy deposit, and at the same time, they also send the rent payment before you sign it as a landlord or as a letting agent. Now that is a breach of the rules. So you're going to have to be really careful to say, do not send me the rent before I sign the agreement. Or maybe it would be easier to have both after the agreement is signed. But the whole thing is complicated.
Simpler regulation.
And another thing to bear in mind is that the amount that a tenant pays for the initial rent cannot be more than for subsequent rent payments, because this is to try and get round the potential loophole that somebody would ask for a big amount of rent for the first rent payment and then lower rent payments later on. Let's move into the rules about paying rent in advance once the tenancy is entered into. So, landlords won't be able to ask for more than 1 month's rent at any time during the tenancy. And so also under the new rules, if a tenancy agreement has a clause that says rent is due in advance, it will be null and void. And due in advance in relation to rent means, and I quote, due before the rent period for which it is payable. So let's give an example. Say that the rent period is from the 26th of one month to the 25th of the next month. The rent will be due at the earliest on the first day of the rent period. In other words, the 26th of the month. And the tenancy agreement cannot have a valid term that says to the tenant that they should pay rent before that date. And sometimes you have agreements where they will say if the rent is due on a bank holiday or during a weekend, the tenant must pay it before then. You're not going to be able to say that. So let's take an example of when the rent is due on Boxing Day, the 26th of December. The landlord cannot have a term in the agreement that says that the rent must be paid before the first working day beforehand, in other words, the 24th, Christmas Eve. Instead, the tenant will be perfectly entitled to pay the rent on the day after Boxing Day if it's not a bank holiday and it's not in the weekend, and they won't be in arrears if they do. Also, landlords won't be able to have a clause in the agreement that says that the rent for 3 rent periods is due every 3 months. So a little way to get round it. And Matthew Pennycook has been on the hunt for loophole avoidance and things. And as you can see from this little clip in the House of Commons committee, when he specifically asked the lawyers that were the witnesses for the committee if they'd spotted any loopholes that need closing.
Our intention with this bill to address the various deficiencies, omissions, and critically the loopholes that existed, whether there are any remaining loopholes in the bill that you can see more disreputable landlords trying to exploit.
And a slight bit of good news is that unlike the pre-tenancy rent, once the agreement has been entered into, it won't breach the Tenant Fees Act to have the clause. It just will be unenforceable and the tenant can ignore it. So I've been asked, what happens if the tenant pays early voluntarily? Is that going to be a problem? And the answer is no. So if you have a tenant who pays that rent due on Boxing Day, if they decide to pay it on Christmas Eve, then that's fine because the landlord isn't trying to get them to do that and there's no clause in the agreement. And as I said, that won't be a breach of the Tenants Fees Act as far as we know at the moment. So that's about it. You might feel that you need a lie down now to get your head around these rules. Why on earth they made them so complicated, I do not know. And let's hope that sense will prevail. And do bear in mind that the rules may change as the bill progresses through Parliament. And Angela Rayner or her successor will be able to change the rules. But this is something that we just need to be very aware about. And if it goes through unamended like this, we are going to have to look at our processes to make sure we don't inadvertently commit a breach of the Tenant Fees Act by asking the tenants to pay for the rent before the landlord signs the agreement, which is what often happens now. Also, have a think about whether any of your tenancy agreements have rent periods that are longer than a month. You might want to try and get that sorted out before the Act comes into force. If you found this useful and you've recovered from the disbelief and shock, please give it a thumbs up. And you can also sign up for my weekly newsletter for free on the independentlandlord.com subscribe. For more insights into the Renters' Rights Bill, and I promise you the rest of it is a lot easier, take a look at my free training course, Renters' Rights Bill Explained, and the updates here. See you soon.